session to order. So, just a quick overview of what we can expect today. We're going to start off with Amy, just kind of walking us through a juvenile court 101, the difference between dependency, delinquency, what each of those systems look like when a case comes into Amy's office, and then I've asked her to share just a little bit about sort of how the experience has gone so far with the circuit court. And then Candy Humphreys is supposed to be joining us here shortly as well, and she will be sharing Casa's role on the dependency side, sort of walking through that. And then I also have asked her if she has any thoughts on the current system versus the circuit court system, just to share any observations or her thoughts on that. And then Marion, of course, is in the room, and so I don't know that you had anything necessarily formal that you wanted to present, but if we have questions, or Marion might be engaging parts as we go through. And then as a reminder for folks in the audience and listening that we'll have then 2 public listening sessions on the 4th and then on the 17th, although I'm going to talk about the 17th a little bit later to see if that's going to work. That will allow the public to weigh in and take feedback before we decide if there's something we want to make a change or keep the current system. So with that, I will hand it over to Amy to walk us through Juvenile Court 101.
Good morning.
Good morning.
So I put together a little PowerPoint. Please feel free to stop me and ask questions, whatever you need clarification on, but just to do a brief overview. How cases work when they come into the Gilliam County Juvenile Department office. So we have 2 different types of cases that we handle. I handle delinquency and dependency cases. So the differences are that a delinquency case is the violation of a law prior to a youth's 18th birthday, which it would be a crime if committed by an adult. And a dependency case is where we ensure the safety and well-being of a child who DHS determines is at significant risk of becoming abused or neglected, and in these cases, no violation has been committed by the youth. That does not mean that there aren't times where a youth in the dependency system also has a delinquency case with me. That can happen, but there are 2 different types of cases. DHS isn't really involved in the delinquency side of things, whereas they are involved in the dependency side of things. So,
you're very well. Oh, excuse me.
Okay. When a delinquency case comes into my office, these are the steps that happen. So step 1 is a youth commits a crime or has a violation. A violation would be something like a minor possession of alcohol versus a crime that we can like that. So I get a police report from local law enforcement. And then after I have time to review the police reports, and Marion, our district attorney, also sees the police reports, him and I discuss maybe how we want to handle this youth moving forward. And then I meet with the family. I do an intake. I have a risk assessment that I do, kind of questions, kind of time to get to know the family. And then I talk about what their next steps are going to be. So I kind of let them know how the process is going to work moving forward. And so these are the 2 paths I can take with the family. We can offer them a formal accountability agreement. And this is often used for first-time offenses, particularly less serious than somebody with your minor possession of alcohol or something like that. I'll offer them a formal accountability. It's an agreement between the youth and myself that if they complete it, means they can avoid coming before the judge. So when we do formal accountability agreements, they don't file a petition with the court. It's all handled within my office. They do still have the right to an attorney to go over the agreement, to guide them in what I'm recommending. There are conditions that are like similar to probation. There's things that they might have to complete some community service. They might have restitution depending, maybe they stole something and we're offering this formal accountability, but they need to pay back the cost of what they stole. But it's all handled between the youth and I. pending the youth follows the agreement. The youth knows, and it says in their agreement that if any time, if they have another police report, if they're not following the conditions that we agreed upon, then at any time I can do a formal accountability, file a petition with the court, take them to the judge. The second one is the court process, and these are for more of our serious offenses, more of the maybe form of accountability. We might not think we'll work with the youth. Maybe this is a second, third offense that the youth has had. And in these cases, we'll file a petition right away with the court. The youth goes in front of a judge. If by chance we have to detain the youth, we have to by statute hold an emergency right within 36 hours, business hours. So youth cannot just be thrown in detention or court without.
Business hours, so they can't be in there over.
They can be there over the weekend. Yep. So after the youth has a court hearing, I need to meet the family again, make sure that they understand everything that's happened in the hearing. I just kind of do a little review. A lot of times families are pretty nervous in court and in front of the judge. So we often just go back down to my office and kind of a more informal setting where I make sure that we understand everything that had just happened. I make sure that if there are conditions of probation that have been ordered, that they have their own copy of that so that they can look at that at home and make sure that they're following those conditions. And I make sure they have my contact information. I'll give them a business card. A lot of times, parents will put my number in their phone. And I let them know that I'm always available. A lot of times, families get home and in the evening they need a question, and weekends, and I have no problem with them calling and asking those questions. So I let them know that I'm pretty much available for them all the time. And then once the youth is either on probation or under formal accountability, I try to touch base with them weekly. This is something I learned from Vicki, and it just kind of keeps it fresh in youth's minds. It helps me monitor to make sure if they have things like community service, are they working on it. We monitor their grades. Studies show that youth are less likely to but have more crimes or be delinquent if they're successful in school. So, and I just do what I can to help them with what they need. Sometimes I need help setting up appointments with counseling or just whatever, just to try to monitor to make sure that they are successful in their probation period and that they can get through this and hopefully move on. So in the dependency case, works a little bit differently. DHS is kind of the one running this. I just facilitate a lot that goes on with them. So DHS will call me and tell me that they need a shelter hearing. They file the initial petition, or they don't file it, they do it, and then I file it with our local courts. And we have to have, when they remove a child from their home, we have to have occasionally 24 business hours again. So yes, it can go through the weekend. So we have a shelter hearing. That's where we just go in front of a judge and let them know that the child has been removed. And then we set another hearing for an admit deny. And that has to be held 30 days from the day we file the petition. And what an admit deny is in the petition, DHS has listed allegations, which are the reasons they removed the child. So they can list, whatever the reasons are. There's drug and alcohol use in the home is unclean, the home is unsafe, whatever, and they list them separately for long and for death. And so the admit deny is a time for the parents to come and either agree with those allegations from DHS or deny. And we most often say deny, we'll set a trial date. But we always try to have before the trial what's called a settlement conference. And that's where I contact all parties, we set up a date, and attorneys and parents and DHS sit down together and they try to figure out how they can kind of meet in the middle. So they'll try to, maybe the wording needs to be a little bit different for the parents to be comfortable with the allegations, or maybe DHS is willing to drop the first allegation but not the second allegation. So it's kind of time, we'll try to do it outside of court, to try to come to some sort of agreement. If that doesn't happen, it goes to trial. If it does happen, we come back again for another admit deny where all parties are ready to admit to the allegations in the petition. However, they might have changed a little bit, they might have been enough the way they were, but we'll come back for that. And then within 60 days of the petition being filed, we have to have what's called jurisdiction and disposition. So jurisdiction is what we get when all parties have agreed to the allegations. So then the judge is able to find that the court and DHS have jurisdiction over the family, meaning that DHS is now involved in the family's life. We usually go straight into disposition, which this means, okay, we have these allegations and here's what you need to do and participate in order to get your child back. So it could be DHS is recommending mental health assessment and follow through with any recommendations from that. They're recommending inpatient treatment. Whatever DHS feels is needed for the family to be successful and the child to be safe back in the home. And then after that, we do review hearings every 3 months. They can occur more often if needed. If there's something going on with developments in the case, anyone who's a party to the case can request a review hearing before the judge to review anything new that might be, that's really like vital that it not wait for 3 months. Otherwise, the judge usually hears it every 3 months just to get an update of progress or lack of progress that the family has. And then by statute, we have to have what's called a permanency hearing 12 months after jurisdiction is established, or within 14 months of when a child is placed in substitute care. And they're very similar to review hearings. There's just some legal findings that the judge wants to do at a permanency hearing. And both of these types of hearings, our review hearings and our permanency hearings, continue throughout the life of the dependency case until the case closes.
Any questions about any of this so far before Amy gets into the circuit court piece of this?
I did have a conversation with someone the other day, and they mentioned that we don't have any foster homes in Gilliam County this time. Is that?
We may have one, Sherlock homes, but we are very low. What happens is that we can't place out of the county. Oftentimes, DHS tries really hard to place a family, and then they'll do a temporary foster care assignment. So even though the family member isn't necessarily certified foster home for any child in the system, they're a relative placement for the child, and the child can go in the home. So we try that a lot in Gilliam County with my grandparents. We've even had an adult sibling who was a placement for a child in a case. So we try to keep them as close to home as possible in whatever way we can, but it isn't always possible. So, any other questions?
Oh, wait, not yet.
I was going to say lots, but
Okay.
it's a lot, just a little
It's
bit.
kind of a very small version of what goes on.
Yeah.
So in regards to transferring to circuit court, there's a couple slides here just talking about some of the concerns that we've heard about and what the experience has been so far in the couple of months that we've been in circuit court. I will say it's been a slight blessing, although it hasn't felt like it over the last 2.5 months, that my caseload has over doubled. And the reason that has been a blessing is there's been more time in front of the circuit court judges than we would have had normally, because Gilliam County doesn't have a huge caseload compared to the bigger counties. And we're not always in court on a monthly basis, but lately we've been there almost every week. So it's been, like I said, it's been a mixed blessing because there's been more time in front of some of the circuit court judges than we would have normally had in a trial period. But one of the concerns has been, that we've heard, is difficulty or delay in scheduling hearings. There was a lot of concern about whether they would prioritize us and put us on their docket and hear our cases. So when, beginning in January, mid-January, we took the current cases I had, which I believe was 4 cases, and transferred them all up to circuit court to Judge Wolf, and they all already had review hearings set with Judge Shaver. there was already timelines in place because they were existing cases. One was delayed by 24 hours, and all the other hearings occurred on schedule or before the hearing date the judge had set. So there was no delay in any of those cases being heard. And the one that was delayed actually was not a circuit court judge scheduling problem. It was just trying to get attorneys and judge all on the same page at the same time, which is very difficult to do with county or circuit court. So, and regarding new cases, we've had 3 emergency hearings. So all of those hearings have been where we've had to have that done within 24 hours. And it is statutorily required that we have these hearings in 24 hours, which the circuit court judges are well aware of. And all of them were able to appear for our hearing either in person or video conference. I believe one was in person and I think 2 were by video.
Do you see a difference in the reaction from the families, whether it's video conference or personal?
I do think that having the judge in the room is a preference. But the parents are still, I mean.
It's the authority of having someone right there in a judge's room, or as opposed to somebody on a video screen.
Yes, I think there is definitely more impact having a judge in the room. I mean, it's just, you know, it's like this versus running up at a screen. I think it's easier for being able to hear, you know, communication. I think all of that is easy, but our circuit court judges have, moving forward, they're scheduling hearings at the end of court on days where they can be here and getting attorneys to put it on they're working it out in court now, moving forward. So every case that we've heard in the last 2.5 months, the judges have set the date at the end of the hearing to make sure attorneys and themselves can be in the courtroom. So they are trying to mitigate using the video conference as little as possible and actually coming out here and attending our court hearings.
And really, so far, the video conference has been mostly in those cases where it's a 24-hour unexpected
Yes.
kind of thing that's come up. There's been a few in the early ones that Judge Wolf needed to do via video conference, but most of them.
And then there's some hearings, like we just had one yesterday where there was no one in the courtroom. The parents' rights have been terminated. The youth is in treatment in Utah. It's a dependency case. DHS appeared in the courtroom with the judge in the Dallas, and the only people in our courtroom were myself and Casa. In those cases, would I say it has less of an impact? No, because there's no family in the courtroom. Anyway, there's no youth in the courtroom. DHS was actually with the judge in the Dallas, so the video conferencing was for me and Casa. So impact-wise, I would say that really had no impact because the youth wasn't going to be there anyway. They were on the phone. So cases like that, even though we're using video, I don't feel there's an impact family-wise on those types of cases because family isn't in the room anyway. And then another concern that there's been is the loss of personal connection between the judge and the kids and the families. And what we've got for experience so far is that while it's true the circuit court judges don't have a personal connection with the parties in our cases, they have been very patient and generous with their time in explaining the legal process and options available to our children and families. And this lack of personal connection has also ensured the impartiality of the judge in the case. I've seen 3 out of the 4 circuit court judges. Every one of them has taken time to make sure that the family understands this is what happens if you admit, this is what happens if you deny. They've also taken the time to listen to the family. I think in one case where the mom probably took 15-20 minutes of just talking about her situation, and the judge was never cut her off, never said, you know, this doesn't matter to Kate. I mean, just very kindly listened to everything that the mom had to say, and is spending that time. So yes, they don't personally know the parties to the case, but they haven't taken the time to listen and hear what needs to be heard before they make their decisions. And another concern is, circuit court, so it's kind of a similar, often participating during video conference was less of the gravity of the situation for youth and parents. This was kind of your question, just not Commissioner Wilkins. So they have made every effort to schedule in-person hearings. Have had to conduct some video via conference, or via video conference, sorry. But as Judge Farrar said, in many cases, they've done emergency hearings that happen within 24 hours. And I kind of already did all this answering your question. Of the 3 emergency hearings held, one was conducted in person, 2 were video conference. And I didn't mention when I answered that question, in all 3 cases, Judge Farrar was traveling outside of the county, and she would have had to conduct those hearings by phone as well. So there's no guarantee with the county judge that they'll always be here anyway, since of all the hats that the county judge wears. So, I mean, technology makes it great that judges can appear by phone or video conference, but it can happen in county court as well as in circuit court. And then some additional things to think about is our circuit court judges have a lot of training and experience in these cases. The court orders in circuit court are prepared by a circuit court judge rather than by myself as juvenile director. This makes sure they're legally sound, and it frees the juvenile director up to spend more time with the children and families involved in the case. The county judge is able to supervise and support the juvenile director without creating inappropriate ex parte contacts. And the circuit court covers the costs of attorneys and translator fees for cases under their jurisdiction. And in addition to these costs, the Gilliam County Juvenile Department currently pays for conference calls through a conferencing center, as well as there's a line item for training for the county judge. And transferring the jurisdiction of these cases to circuit court would save Gilliam County taxpayers about $33,000 a year. Any questions?
It's a lot to take in, I know.
It's a lot of information.
Well, Amy's sticking around if you guys want to think about additional questions. Or,
I have
do you have a few? Sure.
So one of the concerns I had, I might as well just get to the big ones. I've heard of other instances, and I'm gonna go ahead and say it, like where we've partnered with Boston County, and things started out really good, and then as time went on, not so good. I was just wondering if that's a concern that anybody has brought up.
I think there's always a concern, is this the right decision or is this not the right decision? I don't think, I don't think likely if we take it away from the county. And it's my understanding, and Les has actually come in office last week and asked me this question, and I don't have a formal answer for it yet, but can we ever get it back? And my understanding is we can't. And the reason why is what Les asked me, and I'm trying to get the official reason. I've talked to U.S. Circuit Court and they're researching that. So yes, there is concern if it's the right decision, but I think based on the facts that we have, the circuit court judges do this on a daily basis. They do have the law degree. I'm personally more comfortable not having to do the court orders, making sure that I don't legally miss anything. I don't think Vicky was uncomfortable with it. She's been doing it for 17 years, so the statutes are always changing. I do have Marion, who is amazing help with all of that, but I just think, and there's no guarantee, every 6 years our county judge is up for re-election, and we hope that whoever it is gets re-elected and stays on for a long period of time, but there's a possibility that doesn't happen and they're having to train a new judge. And our county judges don't sit on these cases very often, so is it a learning curve every time you're back before the court? Because, yes, right now there have been influx of cases, but it ebbs and flows in my department, and there can be times where they're going a month or two without even hearing a case, and then they're busy doing many other things for the county, which is fabulous. But our circuit court judges, this is all they do, is hear these cases, work with the law, and that they care about the families from what I've seen. So am I 100% sure that it won't bite us in the future? I'm not, but I feel based on facts, based on the knowledge and education our circuit court judges have, and the empathy I've seen from them and their families currently, I believe this is a good choice.
Is this something that we could continue doing the way we are doing now, without formally turning it completely over, but just doing it on a case-by-case basis, like, you know, without having to make a decision for quite some time?
I believe it is something we could continue doing. So.
And how does it work as far as saving money? If we just never formally turn it over, but just have them keep doing it, how does that work as far as attorney costs?
We still don't pay for it.
As soon as they transfer, so basically how this works is Amy prepares an order for me to sign that formally moves it over to the circuit court. And when it's moved to the circuit court appoints the attorneys over there, and once that happens, the circuit court begins paying the cost for the attorneys. So for the formal accountability agreements, those Gilliam County would continue to pick up, because it's never going over to the circuit court when that happens. It never even comes into my office when that happens. But in terms of the court cases, that's my understanding.
No, you're correct.
The consortium picks it up, the consortium of, that's how they pay for the attorneys over in the circuit court. We'll pick up those costs once the case is transferred.
And it also does, it also pays for, I talked about the conferences and the revenues. If it's in circuit court, they're paying for there, so it also remains.
And so for people that are concerned about local control and the loss of, us giving up that local control, it sounds like a lot of the situations that you have, you would still continue to handle if they're not second offenses or,
Correct. And even as far as, I've talked to other people, even the cases that, we're filing petitions with the court, all of those recommendations are still coming from the local control. In delinquency cases, I'm doing all of the court reports, and it's all of my recommendations and research based on my work with the family that the judge has seen. And the same thing with the dependency cases. We have our local dependency case workers who are working with these families, and they're the ones getting in front of the judge and making the recommendations. So while you have in the circuit court a judge who doesn't know the families personally, you still have all of the recommendations that are coming from your local offices.
I think that's a lot of what I've heard from people that are concerned about what we're going to do with this is that right there.
Right.
And maybe they're just not aware.
I agree, I've heard that a lot as well. And that's been my answer to people who've asked me that question about the local control is you still have it to a certain degree.
Does a circuit court judge is only going off of what's being recommended?
Correct.
That's
Correct. They don't have any personal biases or knowledge of the family on a small town history of the family, but they do have, but I have that, DHS has that, and they are getting our recommendations from working with the family. We know they don't have to take our recommendations, but they are still hearing where we feel, we're the ones recommending where the case goes.
which is basically the only thing that have to go on anyway.
Yes.
I heard something at some point in time that just talk of possibly involving our justice court judge in this. Is that something that is there only certain things she could actually hear?
By statute, she can't take on all of the cases. She can take on, I believe, like traffic violations, so driving under the influence. But I want to say that's just about all that they can take on. I'm not sure a little more research on that. But I know for a fact, and I did talk with Chris about it, and it was her understanding as well, that they're not able to take on many of the cases that come through by statute.
And the bulk of Amy's case, though, really is the dependency side, as you can probably imagine, in terms of what's going before a judge.
Correct.
The bulk of those are
And none of those
dependencies.
go to justice, correct?
Yeah, those would not. Which was actually also interesting, and when we met with the circuit court very early on in this process, and one of the things that Angie, who's the administrator that I mentioned, I think it's probably been on the record too, was that, and Amy alluded to this, that often or sometimes some of the delinquency cases, you have youth that may be acting out because there's a dependency issue, and so maybe you have a delinquency case that is tracking with the dependency case. And one of the things that Angie had mentioned in the circuit court is they try to track those through the same judge. So that the judge has an understanding of what's happening with the delinquent and the dependency. And so one of the potential downfalls, if you tried to split it, is that you wouldn't have that coordination going through the same court and the same judge. I thought it was worth kind of throwing that, because I hadn't thought about that maybe some of those cases would track, that you might have the same individuals involved with the delinquency as with the dependency.
As a consistency for the family, it's nice to see the same judge. They try very hard for kids not to separate, so that the family's only having to see the same case every time they're going forward. So that is helpful for the family not to hold it.
If we were to decide to transfer to the circuit court, how does that affect, I mean, how would that affect the judge's workload? What percentage of time do you think is really, I know it fluctuates, but if you had to average it?
I mean, I can speak, because right now all I've been doing is transferring the cases, right? So I would say that right now, the other parts of my job are still having me in the office on average between probably 45 to 55 hours a week without even touching the juvenile court side of it. I mean, I obviously am supervising Amy, and so I'm touching base with her about that piece. But in terms of the actual judicial authority, it's about maybe 5 to 10 minutes just reviewing the court order that Amy provides for me. And that's pretty much the extent of my involvement with the juvenile side right now.
Do you think, though, that the time spent in office, I mean, the time that you're having to work on everything now is anything to do with just starting?
I mean, there's the potential. It's hard to know right now. Depends on how many big things we want to do as a board, really, and where we decide that we want to use our time. I would say that there are times when these emergency hearings come up that it is really truly been the case. I mean, I was snowed in on that side when some of these emergency hearings came up that I physically would not have been able to get to Condon to perform those. So,
and I know those times when Judge Schaefer that discussion was difficult because it was not impossible, but these maybe have moved off sometimes, and it ebbs and flows. So there's times when I'm not taking a lot of the judge's time because we're not going to work, and essentially everything else I do, I don't necessarily have to involve the judge. It's mostly just courts and getting ready for court. So, you know, sometimes that could be a few hours in a month, sometimes I'm not doing anything in that month. The initial training for new judges is going to be pretty intense, and the learning curve is going to be pretty intense. So in the beginning, it's going to take more time than it would after the 4-hour training. But it does have to fun.
How would you anticipate that if this is transferred over to circuit court, it would affect your workload?
It really wouldn't. There are a couple of things that are off my plate as far as like I don't have to do the court orders anymore, which took me a little bit of time. But an example, I think since it's transition, if we had one day, because it's really, especially with the emergency hearings, it takes sometimes a long time to coordinate. Filing the petition, getting it from DHS. There's a lot of back and forth between me and DHS getting things ready. And then once we get the petition, getting it filed, finding out who the attorneys are, trying to coordinate with attorneys the time that's going to work for court within that 24-hour period. So on this one particular day, I also had a RAP meeting that day, and I could have canceled the RAP meeting. But I would have had to cancel the RAP meeting if I had to have done the court order as well, because it takes me some time. Like I said, I don't have a law degree. It takes me some time to make sure that everything is in it that needs to be in it. Because what we do with county judges is I draft the court order before court so that they know to legally order in the courtroom. And make sure that they have it in front of them. And then I do a final on behalf of the court to make sure it's accurate. So that part of it is taken off of my plate with the county court now doing it. But it's just around the circuit court, sorry.
And the judges do it, if it's the circuit court.
Yes, they do their own court orders. So that part is taken off. The rest, honestly, is not. I'm still doing all the coordinating, all the facilitating, all the summer conferences. I'm still the probation officer for my delinquency kids, so I'm still doing all of their services, intakes, all of that kind of stuff. So for me, it honestly doesn't take up a lot other than more of the legal piece of it.
What was your background before you became?
I have a bachelor's in psychology, so I do not have a legal background. I was Casa director for 6 years, and Vicky's assistant for 6 years. And then I stayed home and finished my degree for a short time. Worked with all the families as a home visitor, and then took this position when I opened up.
Except for the situation of, I know we kind of briefly talked about if it is the circuit court, that they would be seeing the delinquency and the dependency things, maybe the same judge.
Correct.
Hopefully. But is it possible for us to give up one and not the other?
I believe it is. And that, as we talked about a little bit, Mr. Weatherford and I had spoke with one attorney who actually had mentioned maybe keeping delinquency in county court and putting dependency in circuit courts. So that is an option that would be possible. The rest of the attorneys that I've heard from, only one formally emailed me back for county court today, but I had talked to a couple before Judge Ferrari went to office. The rest would like to see our cases in circuit court just for the legal knowledge of the judge.
Can I put you on the spot, Marion?
Always.
What are your thoughts?
It's really, and I talked to Judge Ferrari when she first started about the subject. It's a rare area where I'm kind of neutral. There are costs that can be paid for the attorneys and so forth, and the decision always is the value of that, keeping those judicial services local, justify the cost. And if I compare it to another area, an area I would not be neutral would be Justice Court. We're one of the last Justice Courts that prosecute misdemeanors in Justice Court, whereas most other Justice Courts have deferred to Circuit Court, and district attorneys prosecute in Circuit Court. And sometimes that's a comfort level, but we have found that the sensitivity to the impact of certain misdemeanor crimes on our community are felt more strongly by a local judge, a judge that resides locally. Because people think of misdemeanors as minor stuff, but most assaults are a misdemeanor. Menacing is a misdemeanor. Harassment is a misdemeanor. Attempted coercions, and all these things. And we've had actually some disappointing experiences in circuit court from time to time with somebody who is a consistent problem in our community and causes problems for not just one set of citizens, but more. And the circuit court judges don't consider it nearly as seriously as the person who hears there and hears from the community about the impact of these crimes on them. And but the juvenile system's different. It's never punitive. Juveniles, particularly with delinquency, might not see it that way sometimes, but it's the purpose of the juvenile system is never punitive. And so we're pretty much always on the same page with the circuit court judge. the punitive part is just the consequences of not participating in their rehabilitative behavior, right? It's like any normal disciplinary situation. But as far as, my thought is some of the disadvantages have always been the ex parte contact. It is the judge supervising the juvenile department while also presiding over cases that the juvenile department presents. And, if your judges are careful, which they generally have been, they draw that line. But I know that line has never been clean enough. And so if Judge Farrar is going to supervise the administration of the juvenile program, she can do that more cleanly if she's not presiding over juvenile cases. That's always been a big issue for me. And in the past I've said, if we're going to have the juvenile department, if we're going to have the juvenile judge be the county judge, we should probably have a commissioner be the direct supervisor of the juvenile department. Because it doesn't, the way it's been conducted in the past is not conformed with clean separation of judicial and prosecutorial functions. So that's been important. But I think if you had prior judges in here, they'd all say it's a meaningful experience for them to impact children by hearing their cases and to supervise probations and to decide sentences that I think is most meaningful for Gilliam County. But I'm not sure we're going to get a different outcome in these cases. I think it's been meaningful for prior county judges to administer and be preside over juvenile cases. But I don't see really that we're going to have much difference. The biggest fear, and particularly in delinquency cases, was would our juveniles be appearing before a judge in person? Because the power of appearing before the judge was essential. I think you make a good point, Commissioner Weatherall. Is it going to start out good? Are the judges going to be here? And then later, everything's going to be by video because they just don't fit us into their schedule? I think that's always a fair concern. But, the hearings that are important for the power of the presence of the judge, it's entry of plea, it's sentencing, and it's probation violations. But like the actual arraignment, where you're introducing a new charge, it's not that important, the presence of the judge, because that's a short session. The judge are reading the rights to the juvenile, and they're appointing an attorney for the juvenile. But it's subsequent, more substantive hearings that the presence of the judge is essential. And it's one of the reasons why in Justice Court it's so important for us to have a Justice Court judge presiding over many misdemeanors, because she's here. She's here 4 or 5 days a week, and we can get people before her. And we only get, the circuit court judges will commit to, we have trials whenever we have them, whenever they put them on the schedule. But they commit to twice a month here. We only bring them here on average once a month, because we try to group all of our cases. If they take over the juvenile function, they're probably going to come once a month, because they've scheduled twice a month in Gilliam County. And so as long as they're committed to that time commitment to our county, I'm not sure that we really are going to see a difference in service level. But I want to say that you're talking to the right person with the juvenile director. She does 95% of the work. My role in juvenile matters is primarily procedural. I work with her more now that we've been doing these cases in circuit court, because I'm more likely to be the presenter outside of a trial. I've always been the presenter at trials. But it used to be, unless there was a problem, the entire process was conducted by the juvenile director. And now I am more involved, but that's fine, because they took away something from me last year. I no longer do jurisdiction for dependency cases. The Attorney General's office does that now. And so that used to be like a month of my year. I will say in terms of the county judge's commitment, it's at least a month per year to be to be juvenile judge. More likely about 2 months worth of her time. And a lot of that's the educational component, because to be continually read on the changing, subtle changes in juvenile law is not a simple thing. And that's why most of the defense attorneys would prefer to practice before a circuit court judge, because they know what they're dealing with. Sometimes they complain. We actually always had great outcomes from our county judges, but the attorneys for some of the other parties, either the children or the parents, they were like, things are different here in Gilliam County, and it's kind of annoying because they're used to a certain set of protocols, a certain system, a certain outcome in circuit court, and then they come to Gilliam County and the rules are a little bit different, because it's the judge can run things how they want to run them. We liked that, actually. It used to be more of a problem with DHS, because DHS would get different outcomes from our county judge sometimes, that they get from circuit, and they would complain. The county judge cannot do that. And we would respond, yeah, they can do whatever they want for the judge. You can appeal their cases to circuit court. But the judge can handle these cases how they want, as long as they're trying to follow the law. So that part of it has changed already. I don't present dependency cases anymore, and those are complicated. And so, at a minimum, if we do keep something in our county court, I think the general consensus is maybe delinquency cases. Dependency cases are so much more time-consuming and so much more complicated and have so many more parties involved that I think almost universally people see merit in circuit court judges handling dependency cases. The question really related, do we move delinquency cases? And I'm still neutral. I've been in that camp where I can see the merit, because I see the merit of justice court for criminal cases, retaining the local judicial control. But given the different purposes of enforcing adult criminal laws and enforcing criminal laws with respect to juveniles, given that the purposes are different, I don't know that we see a different outcome. The only thing I worry about is will the attention to Gilliam County be less in the future than it is in the beginning. But like I said, I wouldn't be neutral if we were discussing the same issue with respect to justice, but I am pretty neutral when it comes to the juvenile matter. And I think you're hearing from my people, and I think Candy's here. He probably has a perspective. I wanted just one last thing, because it's off topic, but I always like to remind the court, on the justice court, we pay for the attorneys for those misdemeanor cases, and it can be expensive for the county. And then is it worth it to the county to have that local judicial control? And my experience is it's definitely worth it. We still do some misdemeanors in circuit court, but the ones that have the most impact on our community, that are misdemeanors, we file them in justice court. Any questions?
I'm thinking that there are not many counties that still handle this the way we do, is there?
There's Wheeler County, Sherman County, and Gilliam County.
Okay. Thank you.
Yes, thank you, Mary.
Candy, do you want to come come up and join us? Sure. I asked Candy to come in and talk to us about Casa and just kind of give an overview of Casa's role on the dependency cases. And then Candy, feel free to share any thoughts you have too on county court versus circuit court and your experience so far. Thank you.
So, I got, I'll go over a little bit here, but you can see most of the reading in your leisurely time. I'm sure you don't have much leisurely time. So, I'm Candy Humphreys, and I'm the Executive Director of Frontier Casa. And Frontier Casa was established a little over 2 years ago when Gilliam County Casa and Wheeler County Casa, they were ran by the counties, merged and set up a 501c3 nonprofit Casa program with their own board of directors. So our mission, of course, is to serve abused and neglected children in both counties to ensure their voices are heard and ensure they receive the services they need to overcome the trauma they have suffered. We also, on the back, I provided you with the ORS, which is 419B.1112, and that is the ORS that is in regards to the Casa program, the court-appointed special advocacies. We don't have to just do dependency. Judges can appoint us. We could do delinquency. Most programs do not want to do the delinquency because they have a hard time recruiting the volunteers just to do the dependency. We have, since I've been here, we have done one delinquency case. Judge Schaefer appointed that one, mainly because he had, in his prior years, the child was a dependency case, and he had a Casa that he had a great effect on him. So we are, I didn't read slides because I didn't know, so I just kind of brought the handout.
This is great.
So, we're mandated service through CAPTA on the federal end of it, through the CAPTA Act. And that basically says the guardian ad litem for every child in dependency proceedings. And the role may be fulfilled by a court-appointed special advocate, which is a Casa. The ORS 419B.112, Casa shall be appointed for every child subject of a petition filed under 419B, which I believe is the Juvenile code, right?
That is correct.
And the next page kind of shows you the diagram of where we fit in. We are a party to the case once we're appointed, which normally at the shelter hearing, I try to attend all the shelter hearings, and the judge says, say, I'd like to appoint a Casa, so I come up with a Casa for that. So our Casa is appointed right after the shelter hearing, if not at the shelter hearing. So we, being a party to the case, we receive all the discovery, we do our own investigations, not whether there's guilt or anything on the part of the family, but our role is what is in the best interest of the child. That's what we're there for. Some people will say our role is to do what the child wants. That's not what we are there for. It's to do what's in the best interest of the child. Sometimes it's the same thing, but it isn't always the same thing. So as you can see, we fit in there with parent to child agencies and the juvenile director. I love it. work close together. So our role is a party to the juvenile court dependency proceedings. We investigate child circumstances, report to the court regarding the child's best interests, and we facilitate the collaboration among lawyers, DHS, and community providers. We also monitor the court reports. We receive state monies. I would love to tell you that we receive $12,000 a year for Wheeler County and Gilliam County to run the program. And it's under the state oversight of the Oregon legislature. And then we were under the Oregon Volunteer Commission until just this year. And they changed this to the Department of Administrative Services. They're in discussion in this session whether to keep us there because it was giving the wrong impression that Oregon Volunteer Commission, we don't need money because we're all volunteers. But you can't run a program without money. So they decided to try to put us under another, didn't want to put us under the legal arm of the state umbrella because they felt then that there would be a conflict of interest. So we're under the Department of Administrative Services. And right at the current time, there's 28 local programs in the state of Oregon. And the standards training and supervision, we have the National Casa Association. In order to be a program, you have to be in good standing with them. You have to turn in a yearly report, a 6 months report. You have to go through a review, an in-house review every 3 years where they come in and look at everything in the files, make sure everything is being done correctly. All the training, all the background checks, everything. Then under that, there's the Oregon Casa Network, which is your state program, which we also answer to. And then you have your local programs. So local program functions are recruitment and training, which I am constantly doing. We try to keep, our board of directors tries to keep an even balance of Gilliam and Wheeler County members. So we try to, because we represent, and I'm a big proponent of that, having dealt with across the county lines and regional lines before, to try to keep the board's balance. Right now.
How's your membership right now?
Pardon?
How is your membership right now?
Right now, we just had one, Vicki Witters, resign from the board. So we are looking for a Gilliam County board member. So recruitment and training, I'm always trying to recruit CASAs or board members if they're needed. The CASAs are always needed. And in the process, we're training, I'm doing a training class for 5 new CASAs right now.
And how many do you currently have?
Currently right now,
That are
I
already
have,
trained?
that are trained, I have 5. One is on a leave of absence, so I have 4 that are active. All of those have 2 cases. You have to go through the paperwork if there's only supposed to take 2 cases. But I have a couple of them right now that have 3.
So how many of those are in Wheeler County?
The volunteers right now, they are all in Gilliam County that are active. I have one that's in training from Gilliam County. I've really been active trying to recruit, but I'm just not getting as many as I am through Wheeler County right now. When we first started, it was just the opposite. The ones in the area that came into the program were in Gilliam County. But let's see, 2 of those retired because of health reasons, and Amy retired because she took a job as juvenile director.
little bit of a conflict right now.
She'll retire someday and I'll get her. So anyway, we have the development of the program, ongoing supervision of our volunteers, administration of the program, and of course running the program itself. Our classes have to complete 30 to 40 hours of pre-service training. National says 30 hours, the state says 30 hours. Frontier Casa says 40 hours. So they have to complete the 40 hours for our program, and then they also have to do 4 hours of court observation time. They commit 10 to 20 hours volunteer work for the duration of a juvenile court case, and they meet with the child at least once a month. As I said, they're parties to the case, so they can talk to everyone that they need to talk with. They can attend like the IEP meetings for the child if they're, there's something they can attend. They can observe the visitations with DHS. They can, between child and parents, they can do just about anything that's needed. They communicate with the DHS caseworker at least once a month, about once a week actually, so that goes on. And they interview the parents, service providers, and other adults that's important to the family. They attend all court hearings and critical out-of-court meetings. Touch on that. Provide written reports to the court and the parties at every hearing. And so that's just a very broad overview of what the Casa program is in our 2 counties. So I probably have a little different viewpoint. I agree with Amy on just about everything that she said, and with Marion also. But I'm here in the role as the advocate for your children. Because these children, dependency or delinquency, they are our children here in this county. And that's my role, is to be the advocate for the child, and that's the program's role. So, so I really feel that having watched, and I attend every court hearing, or I try to unless I'm sick or unforeseen circumstances. Even though I'm not the Casa, I attend the court hearings. And I really feel it's in the best interest of our child to handle the juvenile cases, both the dependency and the delinquency in the local county court. Where there's love, and I feel, you can just kind of feel that in the courtroom, and there's support not just from the families, but from the people around them. The circuit court in our area is a true circuit court, just like the old days when the judge rode around on the horse and made his circuit. That's exactly what our circuit court judges do here. And they are extremely good. I mean, they do know the law. They're excellent. There's nothing I would say against any of them, but it's still the time factor that worries me. Since I've been going to all the court hearings between Gilliam and Wheeler County, I'm going to say that at least 50% of those hearings that have been done by the circuit court judges have been video conferencing. And I do not care for that at all. It's difficult for anyone to sit there and talk to a television. And it's difficult if you're calling in on the phone because only so many people's faces can show up on that television screen. So everybody else might be there on the telephone. And that's very difficult. And I have to say that my Casas all complain to me if they are talking to the television screen because they don't feel comfortable doing it. They're not professionals, they're volunteers. We don't have a training on how to do that. So I really do feel that it does affect, in that aspect of teleconferencing. Yesterday, like Amy said, there's no parents, there was basically the only ones in the court, there was the attorneys and there was the case manager for the child at the facility, there was the DHS, and the judge and assistant attorney general. So, something like that, I'm not saying that those need to be all in person with the local judge or the judge sitting in the courtroom, but that's an exception to the rule. We don't have that many kids that really is that way, that don't have families. But Marion spoke. The judge had some questions. Marion spoke, and there was so much feedback and reverberation, I could not
really?
Yeah, I could not understand what was being said. And neither could, I had my training class there with me, most of them, and they couldn't understand either. And they couldn't understand when Amy spoke, and they couldn't understand when my Casa spoke, because it was an echo going on with the I don't know if it was Monica, I don't know what it was, I'm not a techie, but, there's just different things like that. And so you get a phone line that goes down, or you get a internet goes down, you have to have a postponement of the hearing. And I'm just not comfortable with these things as I've seen them happening over the past couple of years. In a minute to read my notes, I tend to get ahead or behind.
Get on the roll.
Public speaker.
Way over that.
Tell you that.
You're doing better.
Yeah, I'm really saying. I'm a passionate speaker.
Sometimes that's better.
And, the circuit court judges, they all have law degrees. And I can understand, but everybody seems to still have the same checklist that they look at and they go down. And there is the schooling, and there is a lot of reading that Judge Barr would have to do in order to, feel like she is qualified to be the sitting judge on these cases. But it's done, and I think she'd be excellent at it. And I think the county judge, by the time they're through with the education and that part of it, is just as viable as the circuit court judge. I think the local judge understands the uniqueness and individuality of our communities, our children, our families, our resources, way more than the circuit court judge does. Looking at it and how that touches the child, I really, my feeling is that we need that for our children. Again, I'll say that the circuit court judges are phenomenal, but they are covering the 5 counties: Wheeler, Gilliam, Sherman, Wasco, Hood River. And it makes for huge caseloads for them. Just yesterday, I was talking with Mary Beth because I'm trying to set up some video conferencing, so my Casas in training do not have to go down to Wasco County to sit in on some court cases, because it would take them through June here to have their 4 hours in, so that before they can get sworn in. And so I was talking to Mary Beth about maybe setting up something so we didn't have to run down to the Dalles to do this. And so she was looking at dates, and she was looking at caseloads for the judges. And just one judge, one day, I could not believe every 15 minutes, there was a hearing scheduled. So, they will take the time, but they try not to because it sets them so far back in the day that I have felt, especially, there's a couple of cases in Wheeler County that I have felt like it was really being rushed because they set the date and the time between cases they were hearing in Wheeler County. And so it's like, okay, we can all do it here. And the attorneys, yeah, we can call in on the phone here while the judge is actually in the county. But it is, we've got 15 minutes because we're on a 15-minute break from this trial that's going on. And so let's get it done. And I have felt the frustration of some of the parents and some of the grandparents who you can tell feel like they're being pushed and just not really being heard because of the time crunch. So I just don't feel that with their busy caseload and their court dockets that they can invest the time and support like a local juvenile judge can with a smaller caseload. And as an advocate for the child, I like to caution the court about losing focus of the control of our children being local. You just can't have that when you're outsourcing. And you're losing further contact the more you outsource things. Local courts have a lot of success in turning a child's life around and making a viable citizen. And I think we see that. We've seen that in the past. I mean, it's been more than 4. I mean, I've only been with the Casa program for a few years, but in small counties, you still see what happens. And so this is one of the most important decisions you really make. It actually is, as a court member, it's going to be one of the most important decisions that you're going to make for our children. So I just, again, would like to remind you that the decision is in the juvenile court operations to circuit court is going to make the decision, from what I understand also, is going to make the decision for all the judges and all the commissioners that come after you. Because once it's done, it's done. And I think Amy is still looking into that, but from what I've been told, once it's done, it's done. So whatever your decision is, make sure it's 100% certain that this is in the best interest of our children. And whatever your decision is, Frontier Casa will continue to embrace the fact that we enjoy working for your county and for the children in it and with the court. So that's all I have to say.
Questions for Candy?
I have a question, foster homes. We have one foster home in Gilliam County. How many are there in Wheeler County, and where do they go? If there is no relative that can take them in, what do we do?
We have children strung all over, and actually in 3, I could say, well, right now 4 states, because we have one that's an interesting case, because it's a Wasco County case, but we are the Casa for the case, and she's actually living in Washington right now. But we've got one that's in Utah, one that's living in a facility in Utah, one that is living with a grandparent in California. We have children in the Dalles. No. Right now, we have several that are in home placement. which means that if dad was the dangerous, was the one that was making the situation dangerous, dad is no longer in the home, the children are there with mother, and services are being provided. And we're seeing, I think we're seeing that, at least through the local court, we've been seeing that.
Your son was correct, DHS, even though they open cases, they don't always necessarily remove the child. So it might be, they always try to work with the family before they even come before the judge. And sometimes it takes just a little bit more for the family to comply. So, you know, we have one of our cases that the mother is maybe a little neglectful, the home maybe wasn't safe, but they felt like they could work with the mom if there was some court involvement. So the children are still home with the mother, but it is an open dependency case in our courts. Sometimes it just gives them a little more teeth in it for the, you know, the parent to say, for DHS to be able to say, this is court ordered, you need to do, you know, A, B, and C. But the children are able to remain in the home. So they're not always necessarily removed either, Mrs.
Yeah, we have we have a couple in Gilliam County, and we have a couple in Wheeler County that's like that. They still go through all the hearings and everything, and reviews and all of that, just like any other case. We actually have some children that we are now Casa for. I'm not sure how that happened, out of Central Oregon that are living with kinship, their grandparents, which has become a foster home in Twickenham in order for them to be able to live there. So that is a foster home, but it's not one that will take other children. We have the foster home in Condon, which just wants the one and the teenager, from what she's told me.
Oh, okay.
Yes, yeah. And then we have, from what I understand, we do have some children from Untitled County, is it, that's living in Condon, in a temporary foster home. DHS is telling me about that anyway. It's not their case. It's they're monitoring it. So, you know, we say there are no foster homes. Technically, yeah, I guess there is, but no, our children are not in county unless they're in home placement.
Yeah, those are the ones that I mentioned earlier, they get temporarily, and they're certified as foster placement, but just for their own grandchild, their own niece, or a family friend, but they're not, you know, another foster child came and needed a home, they wouldn't be a resource to take that child.
So, if you see one of our classes, and you know they're a court-appointed special advocate on a case, pat them on the back, because in order to meet with their child at least once a month, and none of them hold to that. They will do it way more often. It means they're traveling. So.
Any other questions for Kim?
We're so, thank you.
Thank you so much for coming and spending your morning with us. Thank you.
And so please help me with my recruitment.
Yeah, that was a question I forgot to ask. How can we help you with your recruitment?
If you
Just by
friends or
talking to
family, yes, talk it up, invite me to come visit with anybody. I love one-on-one. In my prior life, I was a salesman.
good role.
Yes, and yes. So I love to talk one-on-one, especially if you know of somebody that's interested and would do well in that. I would just love to just give me a name. Name and address. And especially a board member too.
I was going to say, you need board member too.
Yes,
right?
we definitely need a board member. And the way, it's not all that much time. So when you're talking to someone, the way we do it is we meet every other month in person. We rotate it between Fossil and Condon. We can go farther afield if we need to. And then every other month is by phone conference, a phone conference meeting. So basically, it's 6 in-person meetings a year unless something comes up. And like I said, we rotate between the counties. Okay.
Good question. Thanks so much. Thank you. Any other questions of Amy or Marion or that came to mind while we were sitting here? Or are we good for now?
I have 3 pages of notes, so.
Perfect. Mission accomplished.
I need to go back and relate them to the slides and the presentations and see what else I have.
So in terms of next steps, we have scheduled a public listening session on the 6th? 4th in Arlington at 6 o'clock. And then we had scheduled the one in Condon for the 17th. Amy is not going to be here that day, and so I wanted to just get your feedback on whether we want to proceed without Amy being in the room, or if we would like Amy to be here and pick another date that, what do you guys think?
I think Amy's a vital part of it.
Okay, I just wanted to check before we moved it.
Without her knowledge, we're
So, Amy, do you have your calendar with you?
I do.
Okay,
On my phone, but I got it.
so,
I tried that. I'm just not ready for the phone thing.
I know, I hear you.
Maybe I'll get there.
is there, and we usually try to hold things on Wednesdays, so what about the 24th? There's a Tri-County Court meeting in Sherman County in the morning, but otherwise we weren't scheduled to have any meetings ourselves. Is that doable on April 24th? It's the week after, it would be the week after the one we had originally.
This,
It's
what
in-
happened in Arlington is an evening.
Yeah, this will be.
This would be evening as well, so the public can come after work.
I'm not very good with my phone manager. I feel like I have some, I feel like, I know that my situation at home it causes us some conflicts, and that would take me away I wouldn't have that interaction with mom before, between those
Okay.
meetings. So that means she's with somebody else right through to bedtime.
Okay. How about, we have a regular court on the 1st of May. And we could look at moving the court meeting to 3, doing 3 to 5, and then starting the,
So we've already advertised the budget hearing, I believe, on that day.
For the first.
for the 1st. Okay.
Yeah, we got 1 o'clock, so we have to.
Okay, so how about for now, we'll say that we're canceling the 17th, and we'll circle back and find a date that will work for everybody. Is that work? Sorry.
Yes.
No problem.
No, it's, yeah, really. That was gonna be a really long day for us.
Yeah.
That was taking me, I would have been home, but then I would have that whole afternoon where I was away, so.
It is the summer, that's why I'm gone.
Yeah. So we'll, for now, just for the public's, we'll cancel the 17th listening session and reschedule. We'll figure out a date that works for
Right, Arlington one is at 6 p.m., correct?
6, correct. Here, correct?
Right here.
Yeah.
Okay.
Anything else for now, for the good of the order? If not, I will adjourn the work session and let folks know that we will be back in session for county court at 11.